Welcome to James Madison's Montpelier. I'm Ryan Nobles from NBC 12 in Richmond, continuing our conversation on the Bill of Rights. And I'm pleased to be joined by another distinguished panel, Paul FINKELMAN, who is a widely published historian and a distinguished professor at Albany Law School in New York. Gene HICKOK is a former college professor and the one-time Deputy Secretary of Education in the Bush administration. And Tim Longo is the Chief of Police in Charlottesville and an attorney himself. So we're going to talk specifically about the Second Amendment and the perception that folks have that it entitles you to the right to bear arms. And so, Paul, I'm going to start with you. Specifically, does this amendment protect an individual's right to own a firearm?
No. This amendment is about a militia. The amendment reads, and I'll read it for you, a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. This was put into the Bill of Rights after Madison and other members of Congress looked at literally a couple of hundred proposals for amendments. And what's fascinating is that the first draft of the amendment also included a clause that exempted Quakers and other people who are religiously scrupulous from not bearing arms. So the history of the amendment and the textual history of the amendment was about bearing arms in the military context.
So, Gene, how have we gotten to this point then where the perception is, and the courts have upheld, that it protects an individual's right to bear arms?
Well, I'm going to disagree a bit with what we just heard. But if you look at the debates in the various state ratification conventions around the Constitution and the discussion about a Second Amendment type of issue, they talk about for the common defense. That would play into your concerns for the militia. But in most places, that aspect of the clause is dropped. They were concerned about the right to bear arms. They were concerned about the right to defend themselves against this new national government. They were concerned about a new standing military, something they're very nervous about. And you got to remember, the states were where everything takes place at that time. So I think it's sort of a natural outgrowth of this fundamental sense, unique to Americans, I think, about the right to have a gun.
And Chief, it's we're a long way from where the Founding Fathers
Sure,
were
yeah.
to the reality of where we have today. Is this what the Founding Fathers envisioned?
What's troubling about the discussion is that the level of uncertainty that the people have, the very people who this document seeks to protect, don't have a true understanding of what this and what the forefathers were trying to say when they put this into the Bill of Rights. The fact that the Supreme Court of the United States only talked about the Second Amendment 5 times since ratification of the Constitution, twice in the last decade, and only then said it applies to everyone, and then, oh, by the way, the next year it's it applies to you in the states as well. It's troubling that there's still today an understanding about such a fundamental constitutional right.
Clearly, weapons are a very different category from political rights. And that has to be understood when we think about the Bill of Rights. Now, what the court says may be what the law is today, but that doesn't make it historically correct.
Right. And Gene, as Paul mentioned, the discussions and the conversation that went into what was actually passed, how relevant is that to the way the court applies it today?
Well, I think it's very relevant. I'm a big believer that we should try to determine exactly what the arguments were in favor of any provision of the Constitution and opposed to any provision of the Constitution, because that's part of the way you understand the language of the law.
Okay. All right, gentlemen, thank you.
Thank you.
Thank you.